Welcome. Today I'd like to talk to you a little bit about judgment after trial and what actions can and need to be taken to enforce that judgment. The creditor has gone through the litigation process and obtained a money judgment from the court, entered against the defendant, a judicial determination that the defendant owes the creditor the amount claimed or some portion thereof. The creditor now has a piece of paper from the court establishing that the defendant owes the money, so the question then becomes, how do you convert that judgment into dollars to pay the judgment debt? Because frankly, you want to get paid. First, you've got to locate the defendant's assets. You have to determine whether the defendant has assets out of which the judgment can be satisfied. You may have that information by documents the creditor may already have from the defendant. There may be a credit application with banking information, which will let you know where to garnish. There may be a loan application with a financial statement providing information about the debtor's assets. Or you may even have copies of the defendant's checks in the creditor's files from the time when the defendant was making payments before the payments stopped, which resulted in the litigation. If you don't have that information available to you, the rules of civil procedure allow for post-judgment discovery of assets. That entitles the judgment creditor to inquire into the existence and location of any assets of the defendant by way of either written interrogatories or by way of a deposition for discovery of assets. And that deposition can be a deposition of the defendant, it can be a deposition of the garnishee if you've issued a garnishment, or it can be the deposition of any person who may have knowledge about the existence, the location, or even the disposition of the defendant's assets. These are the means whereby you can discover assets if you don't have information in your file about the defendant's assets already. So you locate the assets, and what's next? Well, the way you go after those assets is through the issuance of a writ of execution. Under a writ of execution, the sheriff will go out and levy upon or inventory the personal property of the defendant, or can levy upon the real estate of the defendant, and list those assets for sheriff's sale, at which bidding will take place and the property will be sold to the highest bidder. Or if you found out that the defendant has a bank account or other accounts receivable, you can garnish or attach that bank account, can attach those accounts receivable. You can attach rental payments received from lessees of the debtor if the debtor owns any rental property on which it's receiving payment of rent. You can attach or garnish any other sources of business revenue that the defendant may have. So in summary, in a debt collection context, obtaining the judgment after trial may only be the beginning. A second battle can begin, being the battle to locate attachable assets of the judgment debtor. If a creditor is proactive and does its due diligence in determining the creditworthiness of the debtor from the day of making the credit granting decision, with an eye toward the possibility that its new customer may eventually become the debtor, then the asset discovery process could be that much easier, and as a result, so could the judgment collection process. But if you don't have that necessary information, always keep in mind the asset discovery remedies for a judgment creditor, which are available through the courts under the rules of civil procedure. Hopefully, this presentation has provided you with some useful information about collection of judgments, and thank you very much.
In summary, how does one convert a judgment into dollars? First, you must locate the defendant's assets. Look at documents the creditor may already have from the defendant, such as a credit or loan application, financial statements, etc. Often these documents have asset information. Inquire into the assets of the defendant per the rules of civil procedure. This can be done by a deposition of the judgment debtor or a third party having knowledge or information about the debtor's assets. So the assets are located. Now what? A few options that the creditor has include an issuance of a writ of execution, a sheriff's sale of personal property, a sheriff's real estate execution sale, to garnish or attach the defendant's sources of business revenue, such as bank accounts or accounts receivable. We hope you have enjoyed this episode of the 5-Minute Legal Master series, where expert, board-certified attorneys help you master today's important legal topics.